Hey guys, as we wrap up 2025 and move on to 2026, I want to touch on some recent AI-friendly MPEP updates. So anybody that practices patent law knows that 35 USC 101 can be a bit of a bear because 35 USC 101 deals with what can be patentable as a matter of law in the United States as opposed to what is new and not obvious. What does that mean? Something can be new and not obvious from a technical standpoint, but nonetheless, the United States might say that, hey, we're not going to allow a patent be issued for this. And that's where 35 USC 101 comes in. And your patent application can be rejected based on that. So every administration kind of flip-flops on how to apply 35 USC 101, especially to software patent applications. And this administration is making a point, in my opinion, that they are going to be more friendly towards those. So if you're going to file a software application, you might want to try to do it in the next few years while this administration is friendly. But without further ado, this memorandum that is the subject of today's video is regarding the advance notice of change to MPEP in light of Ex parte Desjardins. It's not a very long memorandum, so you can honestly read through it yourself. But if you want the highlights, Ex parte Desjardins clarified that much of the advancement in computer technology consists of improvements to software that, by their very nature, may not be defined by particular physical features, but rather by logical structures and processes. I believe that this was kind of derived from the dialogue that a lot of practitioners have with examiners where, they file a software claim that's got a bunch of method and steps in it, but it doesn't have a ton of hardware, and the examiner comes back and says, hey, there's no hardware here. This is, abstract because of reasons X, Y, or Z. You need to add some more hardware here to get this through. And I think that this current administration is making it clear that hardware isn't necessary for these software and AI claims. You should really be looking towards the method and the improvements to the computer technology. Like, is it improving functionality, efficiency, decreasing latency, etc.? And I think that that's highlighted by this point here that eligibility determinations should turn on whether claims are directed to an improvement to computer functionality versus being directed to an abstract idea, right? Because if you think about anything long enough that's like a software method claim, there's an argument that it could, I guess, be an abstract idea. If you really want to make that argument, you can make it. But I think that they're trying to point out here that the proper analysis is whether there is a improvement to computer functionality being done. You shouldn't just immediately try to make it an abstract rejection. In line with this, there have been a bunch of updates to the MPEP. You can see these here. It's probably easy to review in the memorandum. But all of these are pretty friendly. They give you some examples of technical improvements, technical problems. All of that can be put in your specification to basically improve your likelihood of overcoming 35 USC 101 rejections. So I hope this helps. Thank you. Bye-bye.